Hello, my name is Joe Lewis. Welcome to another episode of Justice Now. I'm your host, and this is episode 2 of the educational shows in which I promise to bring you, which should come in maybe a series of 3 or maybe 4 shows. And like I said, this is the second show. Now, what I would like to go over some of the things that I discussed in our first episode of this educational series. And that is basically what we talked about, the history of the Family Court, the Family Court Act, some of the officers that we have in the Family Court, which are judges, magistrates, referees, law guardians, the attorneys, state-appointed attorneys, and the various officials inside these courtrooms who assist the judge, magistrate, and referees in the court. Also, in the first episode, we spoke about some of the judicial and legal terminology used in these courts. I also talked about the various different courts: child support, visitation, and custody, divorce court, and the purposes of these courts. And I spoke in reference to petitions in these courts and which petitions should be filed to get you certain type of judicial remedies, and where to go to get assistance to filling out these petitions, which of course is in the Hall of Justice on the 3rd floor in the Family Court Clerk's office. And I remember letting you know that the women who work in that clerk's office are very professional, very nice, very knowledgeable women. They'll be more than happy to help you with any issues that you may have filling out those petitions. Now, today's show, I would like to talk a little bit more in depth on what happens in these courts during the proceedings, so that you better understand what type of options that you may have in bringing your proceedings to a satisfactory sort of close, or get the type of closure that you may be looking for in these courts. What is basically available there for you to be able to do. And also, you should be counseled, if you have an attorney, on what type of options that you may have as well. And some of the information I'm going to give you will be able to help you be able to really work with your attorney, so you could better sit down and discuss a sort of good game plan for yourself to be able to reach the judicial satisfaction in what you're looking for out of that court. But I first would like to start off with some of the things I discussed and how you go about your first court date given to you in that family court. I did discuss with you the filling out of the petition, the filing of the petition, and the procedures that you would have to go through in order to make sure that petition is properly served and what proper service is. And you will receive that petition back. You will be given a court date in which to appear. And just to refresh your memory on some of the things that I said, one is that you will be given an opportunity to get an attorney. That is the purpose. It is also the purpose of that first hearing is to basically document in the court that you both has appeared, that who is the petition, who's the petitioner, and to make sure that the referee that presides over that case is given proper authority to make the final decisions in your case, which I spoke of a form that would be given to you, and the referee will instruct you on the purpose of that form, which is to give the referee the authority to make the final decision in your case. And you have a legal right, which the referee will inform you of that legal right, to sign that form or not sign that form. Okay? And which means if you say yes, then you give the power to the referee to have the final decision-making power in your case. If you say no, then that final decision-making power is given to a judge. Now, the case still will remain, even if you say no, it still will remain in the court of the referee. The referee just will not have power to make the final decisions in that case. Now, the sole purpose of being brought into this court, the purpose of the proceedings, is to bring forth a judicial remedy that is in the best interest for both individuals who are involved and the child. Most importantly, the child. Now, or children, excuse me. Now, your child or children will be given a law guardian, as I spoke before in my last episode. There will be a law guardian appointed for the child, as well as you will be given the right to seek legal counsel, or you can represent yourself in these court proceedings as well. And if you represent yourself, then the judge has the right to hold you to the standards that she would hold any professional legal counsel that would represent you. So when you make the decision to represent yourself, make sure that you understand this as well, that you will be held to the same standards of any legal counsel that would be appointed to you as well. Now, they will also give you the opportunity that if you can't afford an attorney, to be able to seek legal counsel through the Public Defender's Office, or what they call the Conflict Defender's Office. These are both state appointed attorneys, and they are basically there to assist individuals with legal counsel who can't afford to pay for an attorney. So your first court appearance will be to, number one, acknowledge that there is a petition and that the petitioner and the respondent are both present, and that they are given the right to seek legal counsel or represent themselves, as well as establishing who will make the final decisions. In that case, will you be willing to sign the form giving the referee the power to make the decision, or the judge to make the final decision? And remember that referees are not judges. They are lawyers who are part of a special program that gives them power and authority to hear custody and visitation cases, which is what I explained in my last episode. Now, once these proceedings get underway and you are both assigned your counsel, you are brought back to court. That appearance will be the appearance with counsel. Hopefully by that time, and if not by that time, that is usually when the law guardian is appointed to the case. Now, the law guardian is the lawyer, which they are, I believe they're no longer called law guardians, they are called lawyers for the children. This is where they are now appointed to do an interview with the child, to find out what the child wants. And their job is to interview both parents as well. And the next court appearance is usually set up for the law guardian's report. Now, while these proceedings are taking place, there will be opportunities for your attorney to speak with the opposing counsel's attorney, the petitioner's attorney to speak to the respondent's attorney, and the respondent's attorney to speak to the petitioner's attorney. New York State is a state that believes in the involvement in their family court of both parents. So during these court proceedings, that is a great opportunity to try to negotiate the mother with the father, father with the mother, in some sort of a visitation that would be feasible for both of your schedule and give the child adequate access to both parents. And this is the time that you would usually take the time out to discuss what type of court order you would like, what type of petition, court order you would like drawn up by putting together a petition from both sides, basically requesting what type of things you will be looking for to be placed in that court order. During these proceedings, you have this opportunity to discuss all these things in that court. Now, usually, if an agreement cannot be reached, then the proceedings are usually put down for trial. And you have maybe 2 to 3 court appearances before the referee, before usually it is put out for trial. So you have time to sit down and try to hammer out the and put on the table the differences that you may have, parent, father, mother. Try to hammer through these things so that you both can come to some agreement. Put your agreements in a court order so that that order can be, this agreement can be submitted to the referee, and so that you guys can get out of the court system, move on with your lives, and get about the business of both being parents to your child or children, and raising that child or children based off of the order that you both put together. If not, then you will go to trial, and the judge will look at the evidence presented in that trial. And that trial is usually called a fact-finding hearing, which is where the issues of both sides are aired out. The judge will listen to testimony from the mother, testimony from the father, testimony of any witnesses brought forth, and take very seriously the recommendations made by the law guardian, and come to a decision that they would feel would best suit the best interests of the child involved, or children involved in this case, and thus bring it into the proceeding. And that would usually be the final decision of the judge. That final decision will go into a court order, and that court order will go into effect immediately after the judge has rendered his or her decision in that case. Once again, if you have filed or signed that document submitted to you by the referee requesting the authority to make the final decision on your case, the referee will then have the final say-so. And that petition or that court order, that will be put in place by that referee. And that is it. Final decision. But if you have not filed or signed that form and filed that form with the courts, giving the referee the power to make that final decision, then that case can be heard by a judge, and the recommendations made in that case will be submitted to a judge. And if you don't agree with the decision made by the law guardian, the referee, then and the law guardian, because of course the law guardian's recommendations will be strongly taken into consideration by the referee, then you can appeal that case and to a judge or a higher person of authority that takes the appeals from the court of visitation and custody, which is something that I will discuss further on in the show. Now, these are usually the steps, somewhat depending on the individuals involved, the issues involved in your case, who your attorneys are, your law guardian, and how cooperative you may be as parents. Those are the basic steps that you will probably see or experience in a visitation or custody court. Now, in child support court, proceedings are a little bit different. In child support, you will receive a petition in the mail. Child support petitions do not have to be served. They can be mailed out and sent to you in the mail. And you are to appear on these petitions. Okay? Petitioner and the respondent must appear in court. If you don't appear in court, and these actions that the magistrate can take, I'm going to remind you, can be taken by a referee in a visitation and custody court as well. Once your petition is submitted, mailed out to the respondent and the petitioner, you both must show up in court. Here's what will happen if you don't appear. If you do not appear as the respondent, the judge can order a warrant, which is a body order for the police to have you picked up, arrested, and brought into court. So a body order can be issued for you through a warrant by the magistrate, even by the referee if she so-called or he so-called see fit to do that. But in child support court, it is usually an action that is taken if you do not show up and appear as the respondent. Now, if you are the petitioner in this court and you do not show up, your petition will be dismissed due to the fact that you did not appear. I'm going to say that again. If you are the petitioner, the individual was filing the petition in family court, in child support court, looking for child support financial payments from the non-custodial parent, you being the custodial parent, and you do not show up, your petition can be dismissed. So you definitely want to be there. Make sure that you arrive at the court maybe a half an hour to 15 minutes before your case is actually scheduled to be called, so that you're there and that you don't miss your first court case. Now, usually in child support court, both parties are sent financial affidavits. Now, the financial affidavits is supposed to be filled out by both parties. What they are forms requesting the financial information of both parents. Employment, income from that employment, expenses in the household, how much does it cost for you to live, rent, gas, lights, etc., and any other expenses that you may have, any taxes that has been filed, income tax, etc. It's all requested to be put in that affidavit. And these are requested by the magistrate so that she can or he can better make a decision that brings the judicial remedy that is beneficial to the petitioner requesting that judicial remedy, and also within the guidelines of the law governing child support law in New York State. So both parties are to fill both of these forms out. The forms are not that hard to fill out, and if you do find difficulty in filling them out, my suggestion is to go to the third floor of the family court building, well, not family court building, but the Hall of Justice, excuse me. Go to the Hall of Justice, third floor of the family court floor, go to the clerk's office, ask them for help filling those forms out. Or my number is usually listed at the end of this show. I do court advocacy. I assist individuals in getting those forms filled out, so you can contact me. I'll be more than happy to help you as well in any way, shape, form, or fashion that I can help you. So both of you, petitioner and respondent, either one could call me. You want to get those forms filled out and get those to the magistrate, so the magistrate can better, like I said, make a decision in the case that is within the guidelines of the law and gives remedy to the petitioner that is adequate for them to financially take care of the child or children in need of that child support. Now, in that first appearance, you will be submitting these papers. Now, another thing about child support court you would need to know as well is that unlike visitation and custody court, child support court does not give you the opportunity to seek legal counsel through the public defender's office if you're not able to afford an attorney. They will give you the opportunity to get legal counsel. You can show up with an attorney if you want to hire a paid attorney. But if you cannot afford an attorney, child support does not give you the opportunity to be able to get counsel through the public defender's office or the conflict defender's office. Only under two conditions are you able to get legal counsel if you cannot afford an attorney through the state. One would be if you are the petitioner and your children are receiving some type of public assistance grant. Then you will receive an attorney. That attorney will be representing the interests of the children for the county or Department of Social Services. So it is not really an attorney that is appointed to you per se, but it is an attorney that will assist you in getting any sort of financial remedy that you are looking for through the court, because they will show up to represent the interests of the children who are on some type of public assistance. So in that instance, as the petitioner, you can get some sort of counsel, legal counsel appointed to you by the state. Also, you can get legal counsel appointed to you by the state if you are the respondent. And this can happen in this particular situation. If you have been served with a petition that is a violation of non-payment of child support, you can then, if you cannot afford attorney, you can then be assigned counsel through the public defender's office, because it does have a jail sentence, a possible jail sentence attached to it. So if you can't afford a lawyer, yes, you legally have a right to go down to the public defender's office and apply for legal counsel under that special circumstance, because of course you can be sentenced to jail for non-payment of child support. So in these special instances, petitioner respondent, you can get state appointed legal counseling and legal assistance in child support court. There is also legal aid services that you may call. You also, if you can't afford an attorney and you're looking for some sort of legal representation, you can contact legal aid, see what assistance they could give you. Contact the Monroe County Bar Association. I understand that sometimes they do have pro bono programs where lawyers may be in a position to give you some type of pro bono assistance in representing you in a child support case. And it's to my understanding that lawyers are required to do at least 50 hours of pro bono service every year. And to my understanding, I think that that is a requirement for lawyers to give some type of pro bono service 50 hours a year, and they usually do it through some sort of organization. And there are a lot of organizations that are out there that work with the family court. You may be able to get some sort of legal assistance. So call around, start with legal aid, Monroe County Bar Association, make the call, see what you could possibly do for yourself. But if you can't get help through these, if you don't fall up under these special circumstances, or you can't get help through these certain organizations, then you would have to hire your own attorney to show up in the family court with you in child support. Now, once you show up at that first proceeding, it's sort of similar to the visitation and custody court, where the judge acknowledges that both of you are present. The judge gives you the opportunity to seek any legal counseling or legal representation, if that's what you would like to do, or represent yourself. The magistrate is the individual that would hear the case, so there is no form that the magistrate would ask you to sign to give the magistrate the ability to make, or the authority to make, the final decision in your case. The magistrate will be the individual that will hear the case from beginning to end and has the power and authority to make the final decision. And the magistrate will go into the petition somewhat and what the petition entails. The magistrate will also give you the opportunity, if necessary, or if you would like, to try to see if you guys can come to some type of agreement. Now, if all financial information is not brought in or submitted to the court, there may be another court date given and made for that purpose, for you to submit all of your financial information and get that information into the court, so that the magistrate, he or she, can make the best decision in your case. Now, if all this information is brought and submitted at that first appearance, and there cannot be any agreement made by the petitioner and the respondent or their legal counsel, then what the magistrate will do would put it down for a trial, or what is better known in the family court as a fact-finding hearing. Same thing as a trial. You are able to come in, bring whatever documentation you need necessary to argue your case. Witnesses, I'm not sure of how that may work in a child support case. But you will be able to bring in various documentation, financial proof. You'll be able to argue your case. If you're representing yourself, or if you have legal representation, that is the day that your case will be argued in front of the judge. The judge will give both individuals the chance to present their cases. Like I said, evidence, any financial information that you may have. Witnesses, I'm not sure how that may work in the child support court. I have not seen in my time of doing court advocacy any witnesses in child support court, but that does not mean that you cannot bring witnesses into child support court. The referee or magistrate would also give the individuals, if you're legally represented by an attorney, the magistrate will also give the respondent and the petitioner the opportunity to ask any questions that they may have of each other involved in trying to sift through the facts so that the magistrate can make the best decision involved with the case. Once this is all done, the magistrate gives both of the individuals the instructions, which basically entail her or his time frame in making the decision, rendering a decision in that case. And it usually takes up to about 30 days. In 30 days, you both would receive in the mail the final decision rendered by the magistrate. Now, once that decision has been rendered, that is basically a court-ordered decision that you must follow in retrospect to what you should be paying or what you should be receiving as far as your child support goes. Now, that decision can be appealed to a higher judge, and the instructions of appeal are usually submitted with the judge's decision. So you do have the right to appeal any decision made by the magistrate involved in your case. Now, these are basic procedures that usually take place in the child support court, and procedures that usually take place in custody or visitation. Depending on, once again, the two individuals involved in the case and how they communicate and negotiate, the legal counsel involved in the case, the issues involved in the case as well, all determine, how those procedures are usually handled as far as the time frame goes as they start and as they end. So these issues can play a definite unique role in how the court proceedings take place with each individual case. But what I have given you is a basic skeleton procedural aspect of what to expect in either one of those courts. Now, another thing I like to talk about too is other departments that exist in the family court system that are there for you as well as remedies to seeking any type of judicial relief. Now, these are special departments that have been placed in our family court system, and I would like to read some information to you involving these special departments. Now, since the family court system was first established, its workload has continued to increase. However, Inadequate funding and resources have impeded its ability to handle the needs of families and children who come to it, often in crisis. Issues such as juvenile delinquency and domestic violence have gained greater public attention in recent years. This increased public awareness has resulted in revisions of the Family Court Act, which have allowed the courts to more effectively protect domestic violence victims, enforce child support orders, and improve delinquency proceedings. The court has adopted several innovative problem-solving approaches to deal with certain types of cases. These approaches are discussed in greater detail and below. Courts within the family court. Family court treatment. In the mid-1970s, 75% of child abuse and neglect cases involve parents who use drugs. Non-compliance with court-ordered drug treatment programs for these parents resulted in children remaining in foster care for an average of 4 years. Family treatment courts was consequently established to provide a more effective and efficient resolution for these cases. The family court treatment courts established with the ultimate goal of reuniting children with their drug-free parents, ideally within 1 year. Attorneys for the children and parents, representatives of social services agencies, and caseworkers all work together with a resource-coordinated and family treatment court judge to achieve the best possible resolution for the child involved. In the family court treatment court, only abuse and neglect cases are heard. Parents who wish to participate in the lives of their children must not only admit abuse and neglect, but must also immediately enter a drug treatment program, make frequent court appearances that include mandatory drug screening, and attend parenting classes and support workshops. Visitation with their children continue throughout these processes to provide the child with a much continuity as possible. Integrated domestic violence courts, which are basically known as IDV courts. The integrated domestic violence courts is based on the one family, one judge model. In New York State, domestic violence cases may be heard in family, criminal, and Supreme Courts, depending on the circumstances of the case. This case results in conflicting orders of decisions and unduly burdens the litigants. To address these problems, the IDV courts merges the proceedings, allowing a single judge who is informed of every aspect of the case to hear the case, which allows the judge to order integrated comprehensive social services. The overall goals of the IDV courts are to improve court efficiency, allowing for more informed judicial decision-making, promoting greater victim safety, eliminating conflicting orders, and improving service delivery to domestic violence victims and their children. Also, we have youth courts. Lower level youth offenders may be diverted from formal juvenile justice systems into a continuity-based youth court. In youth courts, an adolescent alleged to have committed a non-violent offense, alcohol or drug use, vandalism, criminal mischief, disorderly conduct, assault, traffic offenses, trespassing, or school violations, must first admit responsibility for the offenses to the police, a probation officer, or a family court judge. The adolescent then appears with a parental consent for a sentencing hearing before a court of his or her peers. These peers, who assume the roles of judges, prosecutors, public defenders, clerks, and jury, are often teenagers who have completed a special training program to do just this. After the evidence is presented and evaluated, the rehabilitative sentence is imposed on the teenager that can include community service, victim resolution, and future services in youth court. Also, restitution. Now here's one court that we hear very little about that usually works as a great remedy for two parents who wind up in family court to discuss visitation and custody, or even child support cases. This is the mediation court in the family court. Throughout New York State, mediation is being integrated into family court processes. In custody and visitation matters, where there is no issue of domestic violence, parties may be referred to the mediation provided by non-profit agencies that work closely with the courts. The state-certified neutral mediators assist parties in drafting their own agreements, which, if approved by a judge or referee, can become an order of the court. Mediators from these non-profit agencies also provide mediation services, sometimes before the filing of a petition, for PINs, and some juvenile delinquency cases. Now, when you go down to the family court system, and if you are an individual that fall within the area of the description in which I just gave in the first paragraph, I would inquire in trying to go through one of these mediation proceedings to try to sit down and talk out what type of remedies may be best suited to be put in an order for both the parties involved. Now also, I did read here that these orders have to be approved by a judge or a referee. One of the reasons being is that both orders, visitation, custody, etc., have to meet the guidelines of New York state law. So that's why they have to be approved by a judge. You can't just put anything in these agreements that may not meet the guidelines of the laws involved. So they have to be overlooked by a judge saying, okay, yes, these agreements are within the realm of these individuals' basic legal rights. And then they approve it. You guys have went through the mediatory services and have put together your own agreement without having to go through the family court, which, in my opinion, because of some of the forces involved in family court, could turn a relatively calm and very easily negotiated situation into a huge, complex fight that may not serve the best interest of the two individuals involved or the child involved. So I would suggest that you make that approach and go and ask, if you can, when you go to the Hall of Justice to file any petitions, or call the family court clerk's office, which is right in the telephone book, and ask them where could they find these sort of mediatory services, and go straight through the organizations, work straight through those organizations through court, And I'm going to make sure that I get a list of these places, and for my next show I'll make sure that I give you information where you can find these mediatory organizations as well. And let me read on. The Child Permanency Mediatory Program is a court-based program currently operating several counties of New York State, which offers an opportunity for adult parties, caseworkers, and attorneys who are involved in the life of the child in foster care to come together in a non-adversarial setting, which is what I was just speaking about, which the family court system can turn out to be sometimes. It also provides the children or child with when appropriated, with a safe place to participate in the permanency plans that will affect them. The program is staffed by full-time, state-certified mediators with backgrounds in the areas of child welfare. In these mediatory settings or mediations, the parties work together to identify and to remove the barriers that are preventing permanency from being achieved for these children or child. Okay. Now I want to go over very quickly some of the issues that will be involved in filing appeals in any of your cases if you do not like the remedies in your family court or your child support courts. So I want to go over that very quickly before the show ends. Okay? Now, filing an appeal. A party that is not satisfied with the final order of the court has the right to an appeal, to appeal the decision and have the case heard by a higher court. In New York State, the Appellate Division Supreme Court handles family court appeals. The lawyers of both parties involved in the case should inform their client of their right to an appeal and are obligated to do so in juvenile delinquency, PENS, and neglect and abuse cases. The attorneys for the parties that exercise this right must file the appeal within a specific time frame. In addition, although parties must be presented an appellate argument, or the parties may be present at the appellate argument, they do not testify during the appeals process. So you have the right to be there to hear that appellate argument, but you do not testify at your appellate argument. Appealing support decisions. Both parties in the support case have the right to appeal their decision of the support magistrate by filing an obligation within 30 days. However, before an appeal can be made to the appellate division, a family court judge must review the decision. The party that opposes the objection has the right to send a reply to the judge, who in turn may sustain the order, change it, or have it sent back to the support magistrate for further hearings. Only after a family court judge has reviewed the case can either parties properly appeal the decision to the appellate division. Okay? So these are the issues and steps that you have to take in a support decision as far as appealing your case. Now, filing a complaint against judges or attorneys. Now, in our next show, these are the things I'm going to talk about. And I'm going to leave us off right there. I'm going to talk about the proper steps necessary in filing a complaint against a judge, against a lawyer, or a law guardian, and what that complaint should entail to make it proper and effective when rendering that complaint to the proper authorities involved. So that if you do run into a situation where you do have a complaint, you will have a better understanding of how that complaint should be filed, what constitutes an effective complaint, and how to file that complaint in a manner in which falls within the boundaries for the individuals who you are filing that complaint with to take the appropriate action if deemed necessary based off of your complaint. That is the end of our second educational class. My name is Joe Lewis. You've been watching Justice Now, coming to you from Channel 15, Public Access Television, the People's Network. Thanks for tuning in. I hope that you find the information given to you in this educational show very, very useful in your proceedings in the family court system. Thank you very much. And in our third show, like I said, we will be getting into more detail as far as how to file complaints against judges, law guardians, and attorneys. Thank you very much. And until we meet again, may God bless you.